Zara Jabari versus Medellin Wellness Clinics Limited, Ontario Human Rights Tribunal, February 11, 2019. Issue: the applicant alleged discrimination based on disability during her employment with the respondent. The discrimination resulted in an increase to her work-sustained injuries, poor accommodations, and termination after she requested, advised by her doctor, a week off of work. The respondent denied the applicant's injuries were due to her working conditions, failed to provide adequate accommodations, and claims her termination was due to theft. The facts. The respondent was directed to provide disclosure under Rule 16.2 of the Tribunal's rules, where he was warned that it might be noted in default under Rule 5 of the Tribunal's rules if he did not provide disclosure. The respondent chose not to comply, failing to fulfill the disclosure request, and did not participate in the hearing. The applicant began to work as a part-time technician for the respondent in November 2015 while maintaining her other part-time position with her former employer, the Vaughan. The respondent offered the applicant a full-time position promising increased wages with bonus and commission opportunities in March 2016, where the applicant accepted and as a result left her position with the Vaughan. Facts continued. The applicant's duties included work on 3 different machines where she was the sole operator of 2 of the 3. Treatments she administered to customers would take over 30 minutes to complete, and she regularly worked with them for long hours. The machines utilized handheld devices that caused irritation and pressure to the applicant's wrists, neck, and shoulders, where the applicant developed chronic pain associated with her tasks. The applicant saw her doctor in December of 2016 because of her chronic pain and was using pain medication to help relieve her discomfort. It was necessary for her to reduce the amount of hours she was working to be able to get treatment for her work-related injuries. New employers were hired, but the applicant had to train them. This training contributed to the applicant's pain worsening. One of the new hires was a manager, Ms. Thomas, where it was made clear that she would be in charge day to day. Facts continued. After many months, the applicant visited her doctor as the pain became unbearable. She began taking pain medication prescribed by her doctor in December of 2016. When the medication did not help within a few months, she went to her doctor again and was given another pain medication to try, which failed to help again. It was established that the applicant needed an accommodation consisting of wristbands and a special chair. The applicant was not accommodated in a timely manner. She waited for many months before receiving an adequate chair and decided to purchase the wristbands with her own funds. After visiting the doctor again in May of 2017, it was suggested by the doctor that the applicant take a week off of work while accessing massage therapy in combination with neck, shoulder, back, and arm injections to help with the pain from working her job. Facts continue. After attending her workplace on Friday, May 5, 2017, the applicant told her employer about her need for time off work, where the respondent shared that the manager, Ms. Thomas, was off sick and proceeded to ask the applicant to cancel all appointments Ms. Thomas had. Later that day, upon receipt of the applicant's doctor's report pertaining to her work-related injuries and WSIB, the respondent displayed upset and told the applicant she would not be receiving any pay, stating her injuries could be resulting from a pre-existing condition. The applicant had received a call from Ms. Thomas, who asked her to take some aromatherapy oils home with her that she would then pick up from her over the weekend. The applicant later found out that the manager and her employer had a fallout where Ms. Thomas was no longer working for the respondent. The respondent then called the applicant at her home that night to ask her why she took aromatherapy oils from the workplace and told her that he would show her. She responded, telling him that she was doing what the manager asked of her as instructed. A few minutes after the telephone conversation, the applicant received an email that stated she was terminated for theft and that if she attended the workplace, she would be charged with trespassing. Arguments. Work injuries were sustained by the applicant due to use of equipment at the workplace. Accommodation was requested and wasn't received in a reasonable time frame, and applicant paid for her own wristbands. After asking for time off from work, the applicant was terminated and accused of theft all in the same day. She was following directions given to her from her manager as instructed to do so by the respondent and had not received any performance issues to date. It was held. The applicant's claim to wage loss resulting from the termination of employment until the time of June 2018, when her injuries healed, is found legitimate. Furthermore, the tribunal's remedial powers are set out in Section 45.2(1) of the Code, which provides the tribunal with the discretion to order monetary compensation for injury to dignity, feelings, and self-respect, to order restitution other than through monetary compensation, and to direct any party to do anything to promote compliance with the Code. The tribunal will assess two criteria when examining what is acceptable in awarding damages for injury to dignity, feelings, and self-respect, the level of seriousness involving the actions, and how these actions affected the person who was subjected to the discrimination. If the event or events caused significant emotional distress and were quite serious in nature, awarded damages will land in a higher range. See Arenukulam versus Best Buy Canada, 2010, HRTO 1880. It was also held. The actions of the respondent were found to be very serious as the applicant was terminated after asking for a leave due to a valid disability, and she was accused of theft. She would have been upset regarding how this accusation would have affected her reputation or ability to attain future employment. The applicant experienced shock, disbelief, and episodes of crying, and sought medical treatment after developing anxiety, depression, and sleep loss. The need for accommodation was a direct result of her tasks at work, where she was then accused of theft, where it was found that the respondent's treatment of the applicant was egregious. The remedy. The tribunal assessed what the applicant would have earned had she not lost her job, and also the wage loss associated with her new job up until her injury had healed, which was in June of 2018. The applicant was awarded $15,728.99 in lost wages. The tribunal assessed all facts and the applicant's submissions to conclude how the events affected the applicant, and awarded $22,000 for injury to dignity, feelings, and self-respect. Implications. For employees, workers have the right to be employed in an environment that is free from discrimination. Terminating an employee under false pretext can be viewed as constructive dismissal, and the employee has every right to assert their right to being treated fairly and respectfully. Workers with disabilities are also one of the groups in our country protected under many laws such as the EEA or the FCP, where discrimination is taken seriously. It is the employee's responsibility to report any experienced workplace discrimination. It is the duty of all persons to report any discrimination infractions they witness or are aware of in the workplace. If a worker feels they have been discriminated against in the workplace, they can file a claim with the Ontario Human Rights Tribunal to seek compensation. Implications. For employers, it is the employer's duty to comply with OHSA and the ESA, as well as observe our country and province's human rights laws. When it comes to work-related injuries that require accommodations, the employer must provide what is needed to accommodate an employee up to undue hardship and without prejudice. If it is found that the employer has breached the code based on disability-related discrimination, it will be taken seriously as presented in the aforementioned case, and the award for damages to the employee can be costly, can tarnish the employer's reputation, and can take up valuable time. It would be essential to determine if the workplace has policies in place that offer an open door for employees to feel comfortable to report and share any issues they feel are necessary to bring forth. Implementing and maintaining a good policy regarding what the employer believes in sets a standard for all to adhere to, demonstrates commitment to a discrimination, harassment-free work environment, and helps curb workers' need to bring a claim against the employer.